Well, I'm here with Brandon Williams today, and I'm sure if you've been following any of the content that we've got here, the vast majority of you'll probably know who Brandon is. For those who don't, Brandon, do you just want to give us an elevator sort of view of who you are and what's led you down this path that you're on right now?
Yeah, I don't even know how to describe myself anymore. I always have fun trying to see the hosts do it. It's always new. It's always a discovery. It's always hilarious as to how people describe who I am and what I do. But basically, I do legal stuff. I do a lot of mainline litigation. I'm sort of the guy who's trying to like tether down the entire sovereign movement. And what that means is I'm trying to figure out I'm digging through a lot of court cases. I'm in a lot of litigation, mainline litigation in federal court, and then now also in state court in America. And I'm trying to sort of tether everything down with evidence, case law, historical background, character research, such as doing extensive research on the history of the specific justices that gave really key opinions. So, for example, like Roger Taney with the Dred Scott versus Sanford case, or Samuel Freeman Miller with the Slaughterhouse cases, and then now I'm starting to get into some other ones as well, some associate judges. So, basically, what it is I'm trying to legitimize the entire movement within the mainstream system. Essentially, I guess is how I would
Okay.
really describe it.
Yeah, yeah, and
And
and obviously what?
what that requires, essentially, in a nutshell, is people always go, "Oh, he's never going to do that. It's never going to happen. They're never going to let that happen." Well, the real answer, the real answer to the question is I need to dig up literally every single irrefutable piece of evidence. Like, if I had 100 irrefutable pieces of evidence for every single major piece of information, at that point there's no denying it, there's no combating it, there is no longer any discussion, there is no longer any argument, there is no longer any debate. It is what it is, and I don't need to talk at all. I just show what I've collected, and then that's it. It's over. Before it's the debate is over before it begins. Essentially, I'm trying to
Yeah,
collect
yeah,
and organize enough evidence to create that kind of atmosphere with this information.
gotcha, gotcha. Well, you talked right at the very beginning there about sovereignty. Uh, So one of the key elements of understanding sovereignty is, who is a person versus who is one of the people. And that is a fundamental benchmark of kind of where we start as well with our audience too, in that people need to understand, what the birth certificate is, how that interacts with, a lot of people use the terminology straw man, don't they? There's all these different phrases that are kind of knocking around here, there, and everywhere. So I would love to unpick that a little bit with you in terms of the person versus one of the people, and how that sovereignty starts.
Yeah, where is the majority of your demographic, your public, your membership? Is it in America or is it in elsewhere
We've
as well?
got people all over the world. We've got a good amount of people here in the UK. We've got a good amount of people in the US, Canada, Australia, New Zealand, um, dotted around in a lot of places. But we do have a substantial audience in the
So
US as well.
so England based or England settled cultures essentially is pretty much
Yeah.
most of your audience.
Yes.
Okay. So what I'll show you is going to be American based, obviously, but I'm sure it's probably the same um, everywhere else because the truth is it's you know it's all the same kind of thing. You just would have to find your own version of it or whatever, right?
Yes.
For your country, but it's probably the exact same overall breakdown. So I have this page here called a treatise on the word person. This is like my coup de grace. This is my masterpiece that I've been working on for a long time, and I released it fairly recently, and then I've been updating it. Um, and this is basically the linear walkthrough with all of the quotes and all of the court cases and everything. So we'll go ahead and just start with this. But your audience is already familiar with a lot of this stuff, so I'm not going to go
Yeah.
too crazy into this beginning stuff. I'll probably skip the beginning stuff. Basically, in America, the word person, if you look in Title 8, which is all about nationality, it means an individual or an organization. And if you look up the word individual, the term denotes a single person, blah blah blah. But in proper cases, it can include artificial persons. So really, it doesn't really mean anything. It's not anything that signifies a man or a woman specifically, right? And then
Yeah.
the definition of the word person being an individual or an organization, you have the definition of organization, which is from that same area, 8 USC 1101. The term organization means, but is not limited to an organization, corporation, company, partnership, association, trust, foundation, or fund, and includes a group of persons, whether or not incorporated permanently or temporarily associated together with any joint action on any subject or subjects. That's what can get a passport. So, a U.S. passport is not issued to a man or a woman, it's issued to an individual or an organization. And the word
Yeah.
individual, I think the word individual means sole proprietorship. So, if you ask me, what's the definition of person from Title 8? It's a sole proprietorship or an organization.
Yeah. I mean, it says
Um,
there clearly whether or not incorporated, doesn't it? Kind of
yeah,
gives it
exactly.
away.
Exactly right. So, um, with that said, going into the original definition of citizen and people, so if we go to the original Naturalization Act in America of 1790 and we look at what was going on at that time, there was some updates that happened to it. There was an update that happened to it in 1795, and there was an update in 1798, I believe, and then there was an update in 1802, and then the 1802 version has been that same version ever since, right? And there are a handful of things that you have to do in order to naturalize as a state citizen, meaning not a U.S. citizen, but a citizen of a state, such as like a Texan or a Californian or a Floridian, right?
Yeah.
You have to previously have been an alien, which means non-citizen. You have to meet the criteria of being what is called a free white person. You have to have resided, meaning you are not a citizen of a state yet, in the U.S. for 5 years as an immigrant with 1 year in the state of application. It was previously 2 years in the earlier acts, and they increased it to 5 years in the later acts. You have to demonstrate good moral character and swear an oath to support the U.S. Constitution. And then you have to relinquish all other or allegiances or citizenships worldwide. If you meet this 5 criteria, then you are able to naturalize into a state. You wouldn't do that through the government. This has nothing to do with U.S. citizenship. This has nothing to do with having a green card. This has nothing to do with any of that. You wouldn't even contact the federal government. The federal government in the United States of America doesn't even have the capacity to process any of this for you. They don't have the ability to deny it to you. They don't have the ability to accept it. They have no ability to have anything to do with or communicate on this subject at all whatsoever. So there is absolutely no point in even contacting them.
Okay.
So, with that said, we have to get into the definition of a free white person. So the definition of the term free white person, the first definition is meaning all persons belonging to the European races commonly counted as white and their descendants, including such descendants in other countries to which they have emigrated. This particular case is a lot more specific, and you can see on the screen here all the different specific nationalities in Europe that they're referring to.
Yeah.
Um, so we're not going to get into all that because it just takes a long time to read it all.
Sure.
But you can see it's very specific as to which ones they are referring to, right? And then at this next point, basically what I do is we go back in time and we go back to where, so in the Constitution, they talk about people and persons. They say we the people. And then there are a couple parts in the Constitution where they start using the word persons, right? And you're going to see what we're talking about here in these quotes. So these are quotes from Roger B. Taney. Roger B. Taney was the fifth um, Supreme, the the fifth Supreme Court Justice, right, of the United States of America, and this is what he looks like. He had some health issues most of his life. He was the fifth Chief Justice of the United States, and he served from 1836 until 1864. And he is the guy who is going to be talking in the Dred Scott versus Sanford case, which we're going to read in a moment. Now, an important thing to know about Roger Taney is he five out of the nine justices at the Supreme Court were slave owners at this time, and
Okay.
Taney was not. He had inherited some slaves, and he had actually gotten let them go. He actually freed the slaves that he did inherit. So when we're reading this, it's going to sound really horrible, but in actual fact, he's not really describing things from his own standpoint and opinion. He's just describing things from a purely historical standpoint. It's just that the history is pretty dark. So
Yep.
I want to make that clear
100%.
before we start reading this, okay?
Yep.
So he says here the words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty. Now, what he's talking about there is really important because when you start digging through a lot of the Supreme Court cases in the 1800s, a lot of the judges, a lot of the justices, especially the chief justices, including Roger Taney, they talk about what's called the Magna Carta, which you're probably a lot more familiar with than most people in America because it's an English document, right?
Sure.
So the Magna Carta comes from 1210, and it's when King John of England at Runnymede basically people said, "Hey man, we need the same powers and rights that you do," and they basically put a knife to his throat, and they made him basically write down and extend all of his powers into his kingdom essentially. So
Yep.
instead of the king holding all the power, that same power was delineated and then extended into the populace, and that's been the operation of England for 800 years. And then when America broke off from England, we took this same system from England, and this
Yep.
this system is the same system that we have in each of the individual 50 states. So legally, from a legal standpoint, each of the individual 50 states operates the same way as 50 little micro Englands. It's the same exact overall structure. So the way you can kind of see that structure in action is something like a grand jury indictment, right? Whoops. So if you look up a grand jury indictments process, right? So the confusing thing that people have a lot of confusion with is we have sovereignty. Is sovereignty individual or is it group? Is it group based, right? And it's kind of that's the part where I think people get confused. So the way that a grand jury indictment works is the sovereignty is actually held by the people, and it's actually the political body that holds the sovereignty, and that sovereignty is essentially a kind of a privilege, I guess you could say, right, for the
Mm.
individual people in the body, inside of the group body. And then a grand jury indictment is essentially 16 to 23 people that are a part of that same sovereign political body, and they're exerting the sovereignty of the group, the power of the sovereignty of the group upon the individual, whom of which has broken the rules or done something unacceptable, and they're either stripping that person of their sovereignty or whatever, right? And that's basically
Yeah.
the basic nutshell of the entire operation of what a lot of people in this arena would call the private or the republic, or there's all these different terms for it, but they don't really explain what it is, and this is what it is. It's a Magna Carta based structure, and it has to do with the sovereignty is actually in the political structure of the entire group, such as a state, and then that sovereignty is pushed upon individuals through grand jury indictments. And that's basically like the whole system in a nutshell, and that's the English system too, right?
Yeah.
Now what happened? Now you're going to see what happened. The grand jury indictment thing has kind of fallen away quite a bit, and we're going to get into why that is and how that happened. But for right now, we'll just continue with this. So the words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of this sovereignty. So you can see Roger Taney's given you a good hint right there. A constituent member of the sovereignty, right? Meaning a part of a whole, constituent member of the sovereignty. So the sovereignty is really, it's a group sovereignty that gets applied inside of with individuals, but it's really the main core of the sovereignty is with the group. It's not with the individual necessarily, right?
Yeah.
Obviously, individual sovereignty composes group sovereignty, but it's really sort of a top-down kind of a perspective, really, when you get into the legal structure of it and how it was designed, right? So in this case, Dred Scott versus Sanford, we're talking about a slave, a released slave who's trying to get citizenship, right? So Roger Taney says here, the question before us is whether the class of persons described in the plea and abatement, referring to what we just talked about,
Yeah.
compose a portion of this people. So now it's like, do these slaves or released slaves or people like Dred Scott, which are called persons, right in the Constitution, we're going to talk about that near the end, and does this class of persons compose a portion of this people, which we just spoke about? This is the people up here. Form the sovereignty, blah, 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 constituent member of the sovereignty, right? And are constituent members of this sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizen in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. In the opinion of the court, the legislation and histories of the times and the language used in the Declaration of Independence show that neither the class of persons who had been imported as slaves nor their descendants, whether they had become free or not, were then acknowledged as a part of the people, nor intended to be included in the general words used in that memorable instrument. It is difficult at this day to realize the state of public opinion in relation to that unfortunate race, which prevailed in the civilized and enlightened portions of the world at the time of the Declaration of Independence, and when the Constitution of the United States was framed and adopted. But the public history of every European nation displays it in a manner too plain to be mistaken. They had, for more than a century before, been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. And I know this is really shocking, and
Truly dark.
it's
Yeah,
going to get
truly,
it's going to
truly
get
dark.
it's going to get darker, so just be ready. But I want you to
Yep.
stop for a second and I want you to think about this. What are they talking about here? Reduced to justly and lawfully be reduced to slavery for his benefit. They're obviously talking about a trust, which I find very fascinating. They're
Okay.
basically saying that the African slaves are property. They have to be property to be put into a trust, and then they're the beneficiaries in a trust. And that's how slavery was actually structured at that time. It was structured as a trust where the slaves are the beneficiaries.
Wow. Okay.
And the assumption or presumption the entire time was that they're being benefited. And the problem was is that if they weren't being benefited, they really didn't have any other option because
No.
they didn't have the right to sue. They couldn't sue anyone. So what are you going to do? You're going to sue somebody for trust fraud? You can't sue anyone for trust fraud. You don't have anywhere you can go that no court will hear it. That was part of the issue, right? That we're going to get into later in the slaughterhouse cases. But let's keep going on this one. He was bought and sold and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or supposed to be open to dispute. And men in every grade and position in society daily and habitually acted upon it in their private pursuits as well as in matters of public concern without doubting for a moment the correctness of this opinion. So basically what Tanny's saying is he's saying, you know, I got rid of my slaves. I'm going up against my own people because there's more slave owners than there are non-slave owners in the Supreme Court. But the thing is that regardless of my opinion and regardless of the opinion of anybody else, there's so much evidence stretching back all the way to way deep into the England Empire, which is like 1705, that there's just this is the facts, guys. Whether you like it or not, whether I like it or not, it doesn't make any difference. That's basically what he's saying, right?
Yeah. Yeah.
And then here we're going to learn about a lot of the countries that you named earlier, including the one that you're from, which is going to be fun. And in no nation was this opinion more firmly fixed or more uniformly acted upon than by the English government and the English people. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, but they took them as ordinary articles of merchandise to every country where they could make a profit on them, and were far more extensively engaged in this commerce than any other nation in the world.
Wow.
So people say slavery is an American thing. It is, but it's not. It's actually an English thing, and it came here with us from England. So to say that it's not an American thing would be false and dumb. But to say that it's originated in or central for America would be just as
Would be
ignorant.
incorrect. Yeah.
Yeah. So this is the shocking part, and then we're going to switch over to finding these two parts of the Constitution. But there are two clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons, and show clearly that they were not regarded as a portion of the people or citizens of the government then formed. So if we go over to Grok, which is the one I like to use for a lot of the legal stuff, it seems to be better for me. And we're going to type in Dred Scott v. Sanford. Mr. Taney said there are two sections in the Constitution which directly prove that Negroes in slavery were not people, but were persons. What are those two clauses? I forget what they are. I've just recently started looking this up, and probably just a few days ago. I've been on a couple of shows in the past few days that I pulled this up on the show, but I haven't memorized.
Yeah. I was going to say this is new to me as well. I've
Slave
watched a lot of your content.
importation clause, Constitution. This one for sure, the slave trade clause. This one here. Yeah. So Article 1, Section 9, Clause 1, restrictions on the slave trade, the migration or importation of such persons. So remember, the beginning of the Constitution is "we the people," right?
Yeah.
So they're saying that in the slave trade, the Negro slaves that are being imported from Africa, they aren't part of "we the people." They are a whole different word called persons.
Yeah. Also classed as articles or merchandise, I think it said in there as well, didn't it?
Yep. And then we have this one here, which is the three fifths compromise. This has to do with representation and taxation for apportionment, right? This one is the one where direct taxes shall be apportioned among the several states, and according to their respective numbers, which shall be determined by adding the whole number of free persons, which is also complicated, including those bound to service for a term of years and excluding Indians not taxed, three-fifths of all other persons. So that's where the whole three-fifths things comes from for slaves. Slaves were considered like three-fifths of a person for the reasoning for representation and taxation and apportionment.
Right. Okay.
So that's what Taney's talking about. He's talking about the slave importation clause, and he's talking about that other clause, right? Um, so basically, this case, as you can see, we were already moving into a civil war. This case really accelerated us into the Civil War, obviously, right? And that really wasn't great. And when people hear it now, they're pretty shocked to see that and hear that, right? Um, and then when you go into the history of it, you realize that Taney wasn't even Taney actually wanted to free the slaves. He actually
Yeah.
I don't think he was the heavy leaner on the free the slaves. I think he was kind of a light leaner, but I could be wrong. I think he lightly leaned more in the direction of freeing the slaves rather than heavily leaning in that direction. I mean, he is the Chief Justice of the Supreme Court too, so he has to be temperate in most of his opinions. He can't be an axe wielder when it comes to his opinions.
Sure.
That just won't work. That just won't work. You know what I mean? So we're coming out of the Civil War, and we have to figure out now what we're going to do about this whole situation. Obviously, the Dred Scott versus Sanford case is still there. So what are we going to do? So the 13th Amendment came out and the 14th Amendment came out, and all the slaves were released, but they just couldn't get citizenship. They were being treated like shit. The courts wouldn't pick up their claims. It was a mess. The states had all sorts of their own independent laws and rules about what they could or couldn't do, and everything was kind of crazy and chaotic. So what they did is there was a series of cases having to do with slaughterhouses in Louisiana, and that case became the case where the U.S. citizen category was born. And that case is called the Slaughterhouse Cases. And the Slaughterhouse Cases was delivered by the Honorable, I think he's a pretty honorable guy, Samuel Freeman Miller. He was not the Chief Justice, he was an Associate Justice. And the
Okay.
reason why they had him give this opinion is because you can see that he was practicing medicine in Barberville, Kentucky for a decade, and then he taught himself the law during that time period, and he was very against slavery, and he wanted to free the slaves, and he got admitted into the bar in 1847, which I think back then the bar was actually more realistic and more real. Um, in 1850, he moved to Keokuk, Iowa, because of he was so strong about slavery, his opinions on slavery. He immediately freed his few slaves that had come with his family from Kentucky. And that's when he started getting into politics and stuff like that. And then he worked his way into the Supreme Court in 1862. Um, and obviously, he was very, very strongly against any sort of slavery, right? So he had been in the Supreme Court for 11 years by the time the slaughterhouse cases happened. So he was in there during the Civil War, and he had been working towards this position and working towards being in a position where he can help to free the slaves for a long, 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 long time. And that's why I think he was chosen to be the one to give this opinion. So, as I'm reading these quotes, he will be the person who is speaking in these opinions. And for anybody who wants to find the original opinions on these, you can just go to Google Scholar, go to the case law bubble, and then you can go and select certain courts and stuff if you want, or you can just type it in. Like slaughterhouse cases will be the first thing that comes up. And then there it is. Click there, and then bang. And then here is the final opinion. It is not the shortest thing in the world,
No.
but we're going to be reading just a handful of quotes from this opinion. But for anyone who would like to go and read the originals, which I do strongly recommend, you would just come here, Dred Scott, and there you go. And you can read Roger
Cool.
Taney here, right? So now we're going to go into the slaughterhouse cases. So the first section of the 14th article, to which our attention is more specially invited, opens with a definition of citizenship. Not only a citizenship of the United States, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by act of Congress. Now, obviously, for those who aren't aware, he's talking about the first clause of the 14th Amendment. For anybody who haven't seen it in a while, all persons
Hmm.
born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Right? That's been talked about since it was supposedly ratified in 1868. There has been documented evidence that it wasn't ever legally ratified because there was a handful of states that were threatened to not be admitted back into the union unless they did accept it, and that makes it a void contract. So the idea that the 14th Amendment was ever even passed is ridiculous, but we live in a world where, the presumption is that it was passed.
Yeah. Yeah.
So when he says the first section of the 14th article to which our attention is more specially invited, he's talking about that first line, right? Opens with the definition of citizenship. Not only citizenship of the United States, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by act of Congress. It had been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It had been said by eminent judges that no man was a citizen of the United States, except as he was a citizen of one of the states composing the Union. Those, therefore, who had been born and resided always in the District of Columbia or in the territories, though within the United States, were not citizens. So what he's saying is that prior to this case that we're sitting in right now, April 14th, 1873, there was no such thing as a citizen of the United States. There was
No.
only a citizen of one of the states composing the Union. And if you weren't born in one of those states, yet you were born in some area within the greater United States area, such as District of Columbia or a territory, for example, American Samoa, the U.S. Virgin Islands, Puerto Rico, Guam, these kinds of areas,
Hmm.
though those areas are technically within the United States, there was no citizenship associated with those areas.
No.
So if you were born in the District of Columbia prior to April 14th, 1873, you had no citizenship. You were legally stateless.
Yeah. Yeah.
Okay. So that's what he's saying there. Then all the Negro race who had been recently been made free men, referring to the 13th Amendment, were still not only not citizens, but were incapable of becoming so by anything short of an amendment to the Constitution. The reason why is because you had to be a free white person.
Yes.
So this is really important. So to remove this difficulty primarily, and to establish a clear and comprehensive definition of citizenship, which should declare what should constitute citizenship of the United States and also citizenship of a state, the first clause of the first section was framed. The first observation we have to make on this clause is that it puts at rest both the questions which were stated to have been the subject of differences of opinion. It declares that persons may be citizens of the United States without regard to their citizenship of a particular state, and it overturns the Dred Scott decision by making all persons born within the United States and subject to its jurisdiction citizens of the United States. That its main purpose was to establish the citizenship of the Negro can admit of no doubt. And then he explains what the phrase subject to its jurisdiction means, which Literally, no one knows. And we're not going to get into it right now. We don't need to, but he literally defines that right here. Next section. The next observation is more important in view of the arguments of counsel in the present case. It is that the distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state, but an important element is necessary to convert the former into the latter, meaning a U.S. citizen into a state citizen.
Mm-hmm.
He must reside within the state to make him a citizen of it, but it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union, meaning District of Columbia, Guam, Puerto Rico. You guys, if you guys have any birds there, you guys are U.S. citizens, but you wouldn't be state citizens. You'd be U.S. citizens.
Gotcha.
It is quite clear then that there is a citizenship of the United States and citizenship of a state which are distinct from each other and which depend upon different characteristics or circumstances in the individual. We think this distinction and its explicit recognition in this amendment of great weight in this argument, because the next paragraph of this same section, which is the one mainly relied on by the plaintiffs in error, speaks only of privileges and immunities of citizens of the United States and does not speak of those of citizens of the several states. Of the privileges and immunities of the citizen of the United States and the privileges and immunities of the citizen of a state and what they respectively are, we will presently consider. But we wish to state here that it is only the former which is placed by this clause under the protection of the federal constitution, and that the latter, meaning state citizens, where whatever they may be, are not intended to have any additional protection by this paragraph of the amendment. If then there is a difference between the privileges and immunities belonging to a citizen of the United States as such, and those belonging to a citizen of the state as such, the latter must rest for their security and protection where they have heretofore rested, for they are not embraced by this paragraph of the amendment. So what is he saying here? He's saying the 14th Amendment only has to do with this brand new class that we're creating now called the U.S. citizen class, and that state citizens have absolutely nothing to do with the 14th Amendment, and state citizens, all their stuff and everything that they have to go for security and protection is everything that's been here since 1776. So if you boil this down, you have two classes of citizenship.
Yeah.
You have one for the white people, and you have another one for every other race.
Yeah. Yeah.
So white people are the state citizens, and they have nothing to do with the 14th Amendment. And then for anyone that wouldn't classify as a free white person, they would be a U.S. citizen.
Okay. Gotcha.
Okay.
Yeah.
So that's the creation of the U.S. citizen category. That happened on April 14th, 1873. Okay. And you can see a case here in the California Supreme Court where they covered this in great detail very clearly. No white person. This is Ellen Van Valkenburg versus Albert Brown, 43 Cal 43. No white person born within the limits of the United States and subject to their jurisdiction or born without those limits and subsequently naturalized under their laws owes the status of citizenship to the recent amendments to the federal constitution. The history and aim of the 14th Amendment is well known, and the purpose had in view and its adoption well understood. That purpose was to confer the status of citizenship upon a numerous class of persons domiciled within the limits of the United States who could not be brought within the operation of the naturalization laws because native born and whose birth, though native, had at the same time left them without the status of citizenship. These persons were not white persons, but were, in the main, persons of African descent who had been held in slavery in this country, or, if having themselves never been held in slavery, were the native-born descendants of slaves. Prior to the adoption of the 14th Amendment, it was settled that neither slaves, nor those who had been such, nor the descendants of these, though native and freeborn, were capable of becoming citizens of the United States, referring to Dred Scott versus Sanford with Roger Taney, right? The 13th Amendment, though conferring the boon, which means benefit, of freedom upon native-born persons of African blood, had yet left them under an insuperable, which means impossible to overcome,
Yeah.
bar as to citizenship, and it was mainly to remedy this condition that the 14th Amendment was adopted. So I use this one a lot because this one you literally can't even argue with this one. You could have a bar card attorney who's been practicing for 20 years and he thinks that you're some crazy sovsit, and you just show him this, and they just burst into flames, like you're just dousing them in gasoline and flicking a lit cigarette at him. There's nothing they can do about this one. This one's like putting him right into a coffin and burying him alive right there in the dirt. So, recently, I don't have it here. Recently, I found another case where Mr. Miller is actually applying the slaughterhouse cases. And I thought that was really fascinating. I have it here. It's brand new. I just found it like 3 days ago. Um, it's down here just a ways. It's right here. Nope, not that one. This is another case where you have a different associate justice talking about the slaughterhouse cases extensively. This is from 1939. It's pretty interesting. We're not going to get into that one though. This is the one. So this is a case, Bradwell versus State, 1873. So this is where you see Mr. Miller applying what he had said in the slaughterhouse cases, right? So he says here, the record in this case is not very perfect, but it may be fairly taken that the plaintiff asserted her right to a license. So it's a woman who's trying to get a license to practice law through the bar.
Okay.
That's what's going on in this case. Okay. On the grounds, among others, that she was a citizen of the United States and that having been a citizen of Vermont at one time, she was in the state of Illinois entitled to any right granted to citizens of the latter state. As regards the provisions of the Constitution that citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states, the plaintiff in her affidavit has stated very clearly a case to which it is inapplicable. The protection provided by the 14th Amendment, that first line or that first clause, as has been repeatedly held, has no application to a citizen of the state whose laws are complained of. If the plaintiff was a citizen of the state of Illinois, that provision of the Constitution gave her no protection against its courts or its legislation. The plaintiff seems to have seen this difficulty and attempts to avoid it by stating that she was born in Vermont. While she remained in Vermont, that circumstance made her a citizen of that state. But she states at the same time that she is a citizen of the United States and that she is now and has been for many years past a resident of Chicago in the state of Illinois. We do not here mean to say that there may be a temporary residence in one state with intent to return to another, which will not create citizenship in the former, but the plaintiff states nothing to take her case out of the definition of citizenship of a state as defined by the first section of the 14th Amendment. In regard to that amendment, counsel for the plaintiff in this court truly says that there are certain privileges and immunities which belong to a citizen of the United States as such. Otherwise, it would be nonsense for the 14th Amendment to prohibit a state from abridging them. And he proceeds to argue that admission to the bar of a state of a person who possesses the requisite learning and character is one of those which a state may not deny. So you're seeing this is a case where he's getting into all of the nuts and bolts and all the mechanics behind state citizenship. So if you have a citizen of Vermont and they're in Illinois, they're a citizen of this country, but they're resident, which means the word resident means not a citizen of, which is another whole rabbit hole, right? That's why he said resident of Illinois, right? So in legal terms, her domicile is in Vermont, and she's a resident in Illinois, but then at the same time, she's claiming to the court that she's a citizen of the United States. So you can see here that this whole subject is a lot more complicated than what people think it is, and I think it's all this complication is what created the whole thing to just get lost, because the state citizen category was pretty much lost by like the turn of the century in the 1900s. I have found very, very little evidence talking about state citizenship after like the year, like, I don't know, like 1895 or something. And
Right. Okay.
Mr. Miller died in 1890. So I think in my head, I think state citizenship kind of went to the grave with Mr. Miller. And
Gotcha.
I don't think he ever intended that at all. I don't think that's what he intended at all, actually. Not even in the slightest. Uh, he intended to give a special kind of citizenship to the Negroes and get them emancipated while still allowing the white people to have the same country they've always known and loved.
Yep.
That's what I
Yep.
think he was trying to do. And it just got horribly lost in translation.
Yeah.
Horribly, horribly, right? So I'm still digging up a lot of cases. I'm going to dig up literally every single case I can. He died in October 13th, 1890. And the slaughterhouse cases happened on April 14th, 1873. So I plan on making digging up every single case between April 14th, 1873 and October 13th, 1890 and seeing I'm going to build out literally like hundreds and hundreds of cases all talking about state citizenship versus US citizenship.
Gotcha.
That's
Gotcha.
my plan.
So where does this fit in with, because we've seen in this terminology, there's been terminology of people, there's been terminology of person, and I want people to understand the differential between those two. What is the definition of a person versus definition of people?
Yeah, it's a great question. So if we go back to the slaughterhouse cases, right? We have an answer for that here. I'll show it to you, right? Um, Let me see here. I think it's the word coolie is what I'm looking for. Here we go. Um, so here's the quote. We repeat then, in the light of this recapitulation of events, like recapping the events, almost too recent to be called history, but which are familiar to us all, and on the most casual examination of the language of these amendments regarding the 13th, 14th, and 15th Amendments,
Yeah.
no one can fail to be impressed with the one pervading purpose found in them all, lying at the foundation of each, and without which none of them would have been even suggested. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freeman and citizen from the oppressors of those who had formerly exercised unlimited dominion over him. It is true that only the 15th Amendment, in terms, mentions the Negro by speaking of his color and his slavery, but it is just as true that each of the other articles were addressed to the grievances of that race and designed to remedy them as the 15th. He's referring to the 13th and the 14th. We do not say that no one else but the Negro can share in this protection. Both the language and spirit of these articles are to have their fair and just weight in any question of construction. Undoubtedly, while Negro slavery alone was in the mind of the Congress which proposed the 13th article, it forbids any other kind of slavery now or hereafter. If Mexican peonage or the Chinese coolie labor system shall develop slavery of the Mexican or Chinese race within our territory, this amendment may safely be trusted to make it void. And so, if other rights are assailed by the states which properly and necessarily fall within the protection of these articles, that protection will apply, though the party interested may not be of African descent. But what we do say, and what we wish to be understood, is that in any fair and just construction of any section or phrase of these amendments, it is necessary to look to the purpose which we have said was the pervading spirit of them all, the evil which they were designed to remedy, and the process of continuing addition to the Constitution until that purpose was supposed to be accomplished as far as constitutional law can accomplish it. So that is the exact quote from the exact court case. The answer to your question is anyone who would not be classified as a free white person.
Hmm.
That's the definition of the word persons. So any class that would not be classified as a free white person. That's the definition of the word persons. And
So
then,
bringing this kind of up to modern times, and obviously the whole movement of people starting to understand that there is this secondary entity or secondary version of them, this, the straw man, the that's tied to the birth certificate. And a lot of people are starting to wake up a little bit to this and starting to look into this and starting to get themselves educated on this. And that's partly what we do, and clearly partly what you do as well. So so we're very aligned in that regard. But if someone was brand new to this and didn't really understand what those differences were, because there's a lot of legal talk in documentation, in letters that people receive through the post when demands are being made. And I guess it's just ingrained, isn't it, into people from birth, because it's all they've ever known, that they are that so-called quote unquote person on that document, whether it be in all capital letters or not. So could you sort of describe the separation between a living man, one of the people, versus that person? And if you can tie that in with the historical details that we've got here and where that all came from, that'd be fantastic.
yeah, that's also part of the treatise. So I just scrolled down to that part here. We have the expanding of the word persons to include artificial fictions, right?
There we go.
So in 1873, due to the slaughterhouse cases, the delineating point between who was persons and who was people was simply the distinction between a white man and a Negro. It could be any culture or any race that's not a free white person, but the whole point of it was for the Negroes. So I say Negro, right? It's that simple. Let's not sugarcoat this, right? Then in 1871, during the Reconstruction of America after the Civil War, we have something called the Dictionary Act of 1871, which you can still see at the very beginning of the United States Code at 1 USC 1. This is what was originally called the Dictionary Act. And this was at the very beginning of the birth of the entire statutory system. Hence, it's called 1 USC 1.
Okay.
Right? So, in determining the meaning of any act of Congress, right, unless the context indicates otherwise, words importing the singular, blah, 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 blah. We're going to skip that. There's some interesting stuff in here. The word insane, insane person, idiot. There's some cool stuff here. The words person and whoever include corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. And the word individual is really complicated. It's just this really convoluted section in 1 USC 8 talking about how, like, the word person, human being, child, and individual shall include every infant member of the species Homo sapiens that is born alive at any stage of development. So that's a whole nother rabbit hole that I
Yeah,
don't really completely understand. It's
100%.
extremely convoluted, right? So basically, to keep it simple, the word person includes corporate fictions, and God only knows what this is. So, and I get into that a lot in my stuff too, right? So if we go to so the beginning of the Dictionary Act in 1871, basically it only applied to federal statutes, meaning it didn't apply to the states directly, right? It wasn't until one specific case where the definition of the word person from the Dictionary Act began to expand and become more commonly acceptable. That case is called Santa Clara County versus Southern Pacific Railroad Company, 118 US 394, and it comes from 1886. This case clearly expanded the 14th Amendment's definition of the word persons, which meant Negroes, or even more specifically, anyone who wasn't a free white person, but mainly Negroes, right?
Yeah.
Here is the exact quote from that case that caused that expansion of definition to occur. And here it is. One of the points made and discussed at length in the brief of counsel for defendants in error was that, quote, Corporations are persons within the meaning of the 14th Amendment of the Constitution to the Constitution of the United States, end quote. Before argument, Mr. Chief Justice Waite said the following, quote, the court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does. So this exact two lines of this exact case in 1886 is what expanded the term persons from people who aren't free white persons, essentially, right? And it
Yeah.
expanded that definition into what was already in the Dictionary Act, which we can see in today's world, for example, at the tax code definitions. And if we were to look up the definition of the word person in the tax code, 26 USC 7701 subsection A1, the term person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. The word individual, it basically, essentially, it means if, and I know I've given a lot of definitions on this, and it's something I'm still working on. After 3.5 years, I'm still working on the word individual. I have tons of circumstantial evidence, but I don't have anything to nail it down 1,000% and put it in a coffin quite yet. I'm still working on that. But essentially, the word individual means any class of living beings that would not be classified as a free white person or as a state citizen. So any class of beings which could be construed to be almost like property or merchandise.
Mm-hmm.
And then if you look at 1 USC 8, 1 USC 8, the way that it's really hard to determine what they're even trying to say in 1 USC 8, but I would say children. Children and infants would be considered individuals. I mean, they are treated as property in the court. Anything treated as property, basically the word individual would be like any living being treated as property, and it would also include sole proprietorships. So anybody who would fit the classification of a free white person and they're above the age of majority, which I believe is 18 or 21, they wouldn't fit the definition of the word individual.
Right.
A state citizen, for sure, 1 billion% through the roof. You don't even need to talk about it. Would definitely, for sure, not fit the definition of the word individual. That I can tell you with complete certainty with the current research. Exactly going through every single race. Some races have special rules and stuff. So to get into all the specifics of what it would or wouldn't include is a larger conversation. For sure, the word individual includes a sole proprietorship. For sure, 100%. In fact, I think when you look at areas like 26 CFR 301.7701-11, and you see it says here, for purposes of this chapter, the term Social Security number means the taxpayer identifying number of an individual or estate. And then you cross-reference that with the SS4 employer identification request application. And you go down to type of entity, which is section 9A. You see here, we're going to cross-reference these. So we have the term Social Security number means the taxpayer identifying number of an individual or estate. If we go over here, we have estate, SSN. Where else do we see SSN?
Sole proprietorship. Yeah.
Sole proprietor.
Yeah.
So the term individual, there's only so there's two types that connect to an SSN.
Yeah.
Individual and estate. So if we do a process of elimination, we have estate here, SSN. We'll check that off.
We don't have individual on the other side.
We don't have individual on the other side. We only have one thing, and it says SSN right next to the motherfucking thing. Okay. Yep. So this and the word individual are the same term.
Gotcha.
So really, if you want to keep it simple, the word individual just means sole proprietorship. Yeah. It could mean children. It could mean different things. It could mean there's more to it, obviously, especially as you get into other titles and stuff like that, talking about different things. But if you just kind of say 90% of the time the word individual means sole proprietorship, you're pretty safe with that
Yeah.
assumption.
And I think this is where
And
people's
the term
understanding of,
straw man is a sole proprietorship. It's
yeah,
not a straw man. And the reason why it's not a straw man is if you go on to Cornell, they have the definition for straw man. Straw man is a third party that holds property in intermission for the sole purpose of transferring it to another. The word straw man and the word escrow is the same term. So when you say straw man, you're really just saying escrow.
okay,
My escrow, my escrow, my escrow. Oh no, that's my escrow on the bill. Now, can the all caps name, the sole proprietorship, operate as an escrow? Sure, but that's not what it is in its entirety. What it is in its entirety is it's a sole proprietorship. Go to the IRS website and we'll read about what is a sole proprietorship. Someone who owns an unincorporated business by themselves. It's a business.
yeah,
And then you got to ask yourself, where did this business come from? And that's when you start getting into birth certificates and everything else. I believe the birth certificate is nothing more than an articles of incorporation for a sole proprietorship.
yeah.
I don't think the birth certificate has anything to do with us at all.
But if that's the case, who formed it to begin with? Where did it come from? Because we didn't ask for that to be put together.
That's correct.
So whose choice
And
was
your
that? You know, because I
and
didn't
your
ask.
parents
I didn't
didn't
ask for
either.
one. You didn't ask for
Yep.
one.
Yep.
Where did it come from?
Yeah, you have a business, and the way that you can prove that really, really easily. Let's say some naysayer was like, "Oh, Brendan is full of shit." I can actually prove it. This I can prove. If you pull out your checkbook, let me put down my thing for a minute. I'm gonna grab a checkbook. Give me 1 second because I don't know if I'll find a picture of it on here.
Sure.
Okay, so I'm gonna go up to my screen. I'll go up into the camera and I'm gonna show you on the checkbook. If you look at the line, I will show it to you.
Oh wow, that is tiny text. There's minute text on that line. Yeah.
That's the signature line on your checks. It says MP. MP stands for microprint, and what it says on there is authorized signature over and over and over and over and over and over and over. If you go into the UCC, if we do another screen share and we go into the UCC, we have a definition for authorized signature. What is the definition for authorized signature in the HANA form? 3-402, UCC 3-402. We're going to find the definition. Um, you just saw it on Google.
Yeah.
And it's very interesting because look at this. So it's a signature made by a person who has the legal right or power to sign on behalf of another party, such as a company or an individual. So they're literally what I'm showing you right now is actual. I don't think anyone out there, and again, I'm not trying to be egotistical. I got 10,000 hours easily invested in all my research, easily,
Mm.
and well over $160,000 in my research, just in projects and experiments and everything else. The fact that your checkbook says authorized signature is 100% absolute unrebuttable evidence that there is a completely separate entity of your name in all capital letters.
Yeah. in itself. And if I
100%
sign as a
direct
representative,
evidence.
yeah,
Yep. That is direct, not circumstantial. When you start getting into the rules of evidence, federal rules of evidence, that's not circumstantial evidence. That is direct evidence. That is direct evidence of proof. You can take that into a courtroom, and that's it. That's the end of the story, right? So this is very fascinating. If you sign as the authorized representative, the rules for signing as an authorized representative is from UCC 3-402. Look at 3-402 subsection B1. If the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable on the instrument.
wow,
So when you understand the basics of, now we're starting to get into negotiable instruments, which we're not going to do because it's going to take me 2 or 3 hours to start going down that
yeah,
path.
yeah. We'll do that another
But when
time
you
for sure.
you can write all the fake checks, crazy checks, weird checks, you can do all this crazy ass shit with checks that you want because you're not the person on the account. You're signing as the authorized representative. You're not liable on the instrument at all. So every single person out there getting in trouble for writing bad checks is just because they don't understand the UCC. You cannot. It's physically impossible to get in trouble for writing bad checks. It's completely impossible. The only way it can happen is Rule 301. And Rule 301 is really the basis of almost everything. It's kind of become like one of the most central points of all of my research. So in the federal rule of evidence, and it's the same in all the states, the rules of evidence are pretty similar pretty much everywhere. I would assume, honestly, they're probably even the same in the UK. I could be wrong, but Rule 301 is called presumptions in civil cases generally. In a civil case, now mind you, this doesn't apply for criminal cases. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. And this here, in my opinion, is basically the primary weapon of all lawyers. And it's the primary weapon of all lawyers that they hope people never find out about. This is the big, huge monster secret of all litigation. This is the secret rule that all lawyers use that they pray to God you never find out about. And this is why people hate litigation so much and why they find it so confusing. This is the rule. So what this rule means is I can make up any horseshit I want and press it across to you. And then now you're saddled with having to prove to rebut that presumption.
Yeah.
It's the opposite of innocent until proven guilty.
Yeah.
It only applies.
You don't have to prove that it's right. I have to prove that it's wrong.
Correct. And it's a little bit more complicated but this rule does not shift the burden of persuasion, which remains on the party who had it originally. So it's sort of like a partial shift. It's not a full shift; it's a partial shift.
Yeah,
but it's enough.
If as long as it sounds plausible.
As long as it sounds plausible. Now, what happens is they make up horse shit, and then what do? You freak out and have some kind of emotional reaction. No, it's not true. Blah blah blah. All this other stuff, right? But the thing is that when you understand this rule, this is the Prince of Darkness. This rule is the satanic club. This is the ultimate weapon that's used by all lawyers. And when you understand this rule, the best thing you can do in all of litigation, the best thing you can do in all of law, the best thing you can do in everything involving anything having to do with sovereignty is just manufacture presumptions at an extreme rate of speed and just overwhelm everyone with presumptions. That's what the lawyers are doing to us.
Mm-hmm.
They write a 14-page brief filled with horse shit. Now we have to go through and clean it all up and clear it all up. You wonder, how is it legal that these people can just write 14 pages of horse shit and get paid for it? This is why.
Because they can.
And when you understand this, now you can start doing it to them. And that's where things get exciting. Now you're going to be the one creating 14 pages of horse shit. And then you're going to force it on them. And then if the judge tries to throw it out, you're going to say, no, judge, under 301, you can't throw any of these out. These are all presumptions that now stand. They have to actually provide evidence to rebut all of those presumptions. And if the judge still throws it out, then you take it to appeals and you say, the local judge wasn't applying and was acting under color of law because he was not applying Rule 301 of the Federal Rules of Evidence or state rules of evidence or whatever. Because, Your Honor, here's a list of presumptions that I created in the original district case, 1, 2, 3, 4, 5, 6, 7, that were never rebutted. They became fact in the case, but the judge decided he was going to go off on his own simulated legal process rather than follow the rules of the court, which if you look in the local rules, the local rules like this are actually considered law within the court. One of the local rules is that the local rules are law. So when you start
Okay.
getting into that, so what you're looking at, Rule 301 is law. So when you start doing it and the judge throws your shit out, then when you go to appeals and you tell the appeals court that the original judge is not following the law. He is manufacturing a simulated legal process. So what I'm trying to do, essentially, in a nutshell, is like I said at the beginning of the show, I'm trying to bring the entire sovereignty platform, the entire subject, into mainstream litigation, mainstream courtrooms. I'm trying to legitimize and provide evidence for. I'm basically building like the biggest court case that's ever happened since 1776. Essentially, that's basically what I'm doing.
Gotcha. Gotcha. And a hell of a lot of hours have gone into that, clearly, and a lot of research and a lot of time. Um, Brandon,
So the straw man thing is not real. It's a sole proprietorship. It's just a business,
yeah,
and everything involving who you are or what that business is falls under 301.
yeah, yeah. And the way
So
that we
so
describe it is kind of like I don't know whether you're familiar with the game Monopoly in the US or not, but
yes,
we class that that entity as your piece on the Monopoly board. And that within the world of commerce, that is what is moving around the Monopoly board
that's
in the
correct.
public.
It's just a
Whereas we as
business.
yeah, it's not you, it's not the living person, and
Well, that there's court cases that have determined that the owner of the sole proprietorship and the sole proprietorship are considered the same person.
mm,
If you want to get away from that presumption, Rule 301, you have to actually go and read. There's a couple cases. One of them is a RICO case. You have to actually go and read those cases because in order to attack that presumption, ideally you would have the actual case law. I'm not even sure it's case law. I think it's an appeals court in like the Second Circuit or something. I don't even think it's. If I go back to Grok, because Grok typically gives me some really good answers for these things, and I type in what were the cases that were done that solidified the idea that the owner of a sole proprietorship and the sole proprietorship are the same person. So, for example, we start getting into presumptions and stuff like that, right? So yeah, it's tax returns. There's a couple of cases about tax returns, and there's one RICO case, right? But the thing is that they're not Supreme Court cases.
no,
So the thing is that they'd only apply in certain. This one's from the First Circuit. So that would only apply on the East Coast. This one's from the Third Circuit. I'm in the Ninth Circuit. So the thing is that these cases, they're gonna push that presumption across, and they're gonna say, oh, the sole proprietorship and a person is considered the same thing. If you don't fight against that, or say something against that, or say something like, whoa, wait a second, what case are you referring to? And then they're going to reference something like Lattanzio versus Comta, which is from the Third Circuit. Your Honor, that's only persuasive authority. That's not case law. This court has no this court has no edict to follow that. So each circuit is legally separated. So if something happens in the Third Circuit, it's used as what's called persuasive authority in the Ninth Circuit, but it isn't actually legally case law in the Ninth Circuit. There are no Supreme Court cases. So the thing is, this whole like the owner and the sole proprietorship are the same person. It's just really just a presumption under 301, just like
Yeah.
almost everything else.
Yeah. Yeah. And the more complicated it is, the more people don't want to dig into that.
That's
I
correct.
think this is, and that's when the fear creeps in. When the letters come and people start knocking at the door. We're currently going through this with many of our members who are, fighting against this, and they need to understand that there is a clear separation between who they are as living beings versus what's on these horrible letters that are turning up every day of the week. It's almost a case of, well, why are you even opening them? It's not addressed to you. you know
My original mentor, who's an older gentleman, he recommends if anything comes in the name, you just write unknown addressee, mail fraud, return to sender, and
yeah,
read, and just stick it back in the mail.
yeah,
And he's been doing that for like 50 years, and it's
yeah,
it's it's very very successful. Let me just tell you,
yeah,
it's a
yeah,
very successful avenue. Does it handle everything? No, but I would say like shit, like 92% of all your issues can vanish.
yeah, because you're just not engaging, are you, at the end of the day,
Yeah.
with something that is not you, it's not your liability, so why would you even entertain that? But it's just the preconditioning. That's what we're all fighting against. Years and years and years of people thinking that they are one and the same. I could talk about this all day. I really
the
could, Brandon.
the area where you start to just real quick on that one point, just super
Yeah.
quick. I know you want to try to get off of here. The sole proprietorship wasn't made by you, obviously, because you would know it. You would be like, "Oh yeah, I remember filing that." You don't because you didn't do
Hmm.
it.
Yeah.
So ownership splits into two categories. You have legal ownership and you have beneficial or equitable ownership, right? You aren't the legal owner of the sole proprietorship. You have equitable or beneficial interest in the sole proprietorship. So the easiest way to think about the sole proprietorship is it is there and designed to benefit you. And if anything at any point in time is not benefiting you, you have to openly and willingly and calmly and without 15 pages of bullshit, excuse me, the activities that are going on right now involving this account, of which I am the beneficiary for, are not benefiting me. This is starting to look like trust fraud. We need to
Mm.
talk about it.
Yeah.
And that scares the fuck out of people. That
Yeah.
scares the fuck out of the IRS. That scares the fuck out of government employees. That scares the fuck out of people. This is starting to look like trust fraud because I don't feel like I'm being benefited. And it seems like you're forcing this on me. Let's talk
Hmm.
about trust fraud for a moment. I'm the beneficiary for this thing. I have beneficial interest, I have equitable interest. So
Yeah.
if you're not going to be benefiting me with these activities, then I'm going to be suing for trust fraud. And you should be suing for trust fraud. You really should be. That's what you should be doing.
As in, are you administering my trust without my consent?
No, well, no, it's what's happening here isn't benefiting me. And I've openly communicated that. So you'd sue for trust fraud. You'd have a letter, not 400 pages, one page. I'd like to bring it to your attention that myself, who has an equitable interest in all caps Brandon Joe Williams, I do not feel as though I'm being benefited, and this situation is starting to move into what appears to be a trust fraud situation. I would like to openly communicate that these are the following things that need to happen or that I feel would be beneficial for me as the beneficiary for this situation. And you would list various things. If you and then at the end, it'd be like, if you have no interest in doing anything that benefits me, then essentially we're either moving into a trust fraud situation, which I will sue for, or just dissolve the trust. Because you have to understand there is no involuntary servitude for them either. They're not your slaves either.
No.
So when you call it out and you say these things aren't benefiting me, trustee, and you can't force them to work for you either. So you give them two choices. This is what benefits me. You either do these things or we dissolve the trust. Which one do you want to do? And for like the IRS, dissolving the trust just means they disappear and they never come back. And they probably put something in the computer of like, don't ever contact this guy again. That's typically what happens. Are they going to send you a letter that says, Mr. Williams, we've dissolved the trust? No, they
No,
are not going to do that.
no,
If that's what you want, you're not going to get that. They
no.
literally just disappear forever. That's what happens. But there's people get confused because there's 9 million different ways of doing it, and I explain all sorts of different ways, and there are a lot of the ways that I explain people have never heard before. The truth is, that's super cool. That just shows you how easy it is to win. There's 9 million ways you can win. It's true. It's 100% true. It's Brandon has got, I think, some great resources. I've got ways to win in 500 different ways to win, right? But there's other people who have other great ways to win too. And
Yeah,
I just think there's just so many ways to win. You shouldn't feel confused. You should feel empowered. That's
yeah,
really how you should feel. If there's
yeah.
900 ways to win the motherfucking game, why is that confusing? You should feel like this is awesome. Crack open a beer and have a cigar. What's the problem with having 900 ways to win? That's not confusing.
No.
There's nothing overwhelming about 900 ways to win. How is that overwhelming? 900 ways to lose, that'd be overwhelming.
Yeah.
But we don't have 900 ways to lose. We got 900 ways to win. And I think people really need to understand that.
Yeah, and I think that's what's so exciting now in the age that we're living in, where more and more people are. I mean, you've got a huge audience. We've got a huge audience. I think this is where when we get expertise together and we're all moving in the same direction, but in slightly different ways. When we form those kind of partnerships, those relationships, and everybody starts to align, it's the whole. We talk about it in our house quite a lot because our children, we definitely want them to understand when they're of age how this works, 100%. And there's subliminal messages in films and even kids
Yeah.
films. The one that comes to mind right now for me is Bug's Life. The ants and the grasshoppers, and just the masses not understanding what the elite are doing here to
Oh, yeah.
subjugate everybody. And if they only woke up en masse, it would all change so very, very quickly.
I feel like the legal area is the best place to wake people up because, and the reason why is because it's like a doorway. Waking up is like a doorway. And the way that you can get people through the doorway is by throwing benefits on the ground and then luring them through the door with the benefits. It's the same thing the elite are doing. The
Mm.
elite are using the benefits to take people down their road, right?
Yep.
And the way I look at it is we need to be doing the same thing to take people on the higher road, right? There's so many benefits. It's like you hear these guys online, these conspiracy guys talking about this, talking about that. There's no benefits. Like, yeah, okay, fine. Like, I learn that, sucralose isn't good for me and I'm going to stop using it. I don't know, maybe like things like that, right? But a lot of it just creates fear and anxiety, really. A lot of the conspiracy stuff, right? The law stuff is like you can go out and you can do something with this information pretty much right away. I mean, I talk about a lot of historical stuff because I think it's required to understand some of the deeper concepts.
Yeah.
But you're going to go out tomorrow, and let's say the IRS knocks on your door tomorrow, and they say, are you a U.S. citizen? If you've never been exposed to any of this, and you've just heard me talk a little bit, minimum you're going to stop and think, oh shit, what Brandon was saying, I'm not even sure anymore. Just that alone, just that little crack in the door. But what you do is you lure people through the door with the benefits, and there's so many benefits. Your audience is obviously well aware of this. There
Yeah.
is no other field in the world besides maybe some sort of like religious rapture that has more benefits than what the legal world can give someone.
Mm. Mm. Well, listen, I truly appreciate your time today. It's been fascinating. The content that we've kind of covered today is definitely new, something that I've not looked at before, and I've looked at many of your videos. So I appreciate you bringing that to light. It looks like that's
This
something
is
that
all new stuff,
yeah, I
and
thought it was. Yeah,
a lot of
what
it
I
has
would
to do
love
with
to
me
do on a
trying to get traction in the courts, so
sure,
which is
yeah.
difficult. But
Well,
yeah,
I would love to have you
I'm just going
back.
to keep building the story, keep building the linear, keep building the evidence, keep building the case law until I get traction in the courts. If I have to write a fucking tome, if I have to create a whole movie of evidence, if I have, I don't care what I have to do. I'm just going to keep digging until I get traction in the courts.
Yeah.
There will be a point where they can no longer shut me out. You just can't do it.
Well, I love your commitment. I really do. And I'd love to have you back and have another
Sure.
chat about some of those other things, because there's so many different subjects that we could talk about. We could talk about money. We could talk about negotiable instruments. There's all
Yep.
sorts of stuff that we could really kind of dig into here, which I know would fascinate our audience, and they'd definitely be aligned with that for sure.
Oh yeah.
So for now, thanks ever so much for coming on, Brandon. Appreciate it a lot. And
Yeah, and if anybody wants the information from the presentation as well as a lot more, we just went over like maybe 20 or 30% of that presentation.
yeah,
You're going to go to williamsandwilliamslawfirm.com, and then there's a page. It's a main page. It's called the Treatise on the Word Person. And you can go down. And then at the top of the page is also a link to a YouTube video where I do a live in-person demonstration. It's very intense, me just screaming, and it's a very, very intense presentation. That's also available by clicking the link and then going to the YouTube. That's not the full treatise. It's only like maybe 40% of the treatise, but it's
okay,
cool to kind of listen to that and then maybe
yeah,
read it. But there's a lot more there for people who are interested in this and they want to read the rest of what I was going over in the show.
fantastic. Thank you for that. Just one more time. That's Williams and Williams.
Lawfirm.com. And then it's
Okay,
the treatise on the word person.
perfect. Thank you, Brandon.
You're welcome, guys. See you later. Thank you.